This is lecture 2 for topic 9, and in this lecture, we're going to be taking a look at the evolution of sexual assault law. Today, for the most part, sexual assault is taken very seriously by the criminal justice system. And we have feminists and allies to thank for the changes to sexual assault law in the United States. As you'll learn in your textbook, in the 1960s, feminists and their allies were at the forefront of identifying sexual assault as a problem, getting it on the agenda of the media and on the agenda of lawmakers, and then working with lawmakers in order to make significant changes. And so today, the stigma of pressing charges, the fear that the criminal justice system will not take the complaint seriously, and the uncertainty of conviction have been significantly reduced. But they have not been eliminated, and problems regarding the prosecution of sexual assault continue to persist today. Obviously, it hasn't always been the case. The criminal justice system hasn't always taken sexual assault seriously. And in fact, for most of our country's history, they have not taken it seriously. And so this lecture will examine those changes, the evolution of sexual assault law, and how those changes were achieved. Now, if we were together in a face-to-face class, and I wish that we were, we'd watch this video together, but we're not together. So I have posted, and I can't play it on the slides. It just doesn't work that way. So I've posted this informative video, kind of a comedy parody sort of video, entitled "If Robbery Report Was Treated Like a Rape Report." So if you didn't get a chance to take a look at that video, I'd like you to pause the lecture, take a look at that short video. It's less than 2 minutes long. And that video is posted in the lecture section on Canvas for topic 9. Okay, so even though the video that you watched is sort of funny, it illustrates persistent assumptions about sexual assault. One of the things you see in the video is that they're coming to investigate the robbery of a laptop, right? To sort of show the absurdity of how we treat certain crimes one way and crimes of sexual assault a different way. And you see in that video that, right from the get-go, the law enforcement assumes that the victim as it is at fault, that they did something to bring upon this crime. Also, like, you sort of see in the video, they're sort of saying, ooh, you got your laptop has the retina feature. Ooh, sexy. It kind of speaks to that when you're, reporting a sexual assault, there's this assumption that the crime is treated more as something that is sexual rather than violent in nature. It assumes that the victim is lying, or if not lying, that they don't really know what they're talking about. So it kind of discounts the testimony of the victim. You see that in the video, they're like, well, how do you know that your laptop was stolen? The doors weren't busted open, the windows aren't open. Maybe how do you even know that it was stolen? And so it plays into this assumption in about sexual assault that if there's no apparent physical harm or intrusion, then how do we even know that an assault took place? And we'll just assume that assault hasn't taken place. And then you see that the cops are sort of sending this message, are like, are you sure you want to, submit a report about your stolen laptop? So this idea that, when it comes to sexual assault, that pursuing the case actually there's more harm associated with pursuing the case than benefits that come from it. And so, it is a funny video because it sort of, turns the tide so that we're seeing it through the lens of robbery, or a burglary in this case, rather than a sexual assault. But it really does highlight the way that sexual assault has been treated differently by the criminal justice system for much of our nation's history. And so that keep these assumptions in mind about the victim being at a fault, no apparent physical harm, no assault took place. Keep all of those in mind because it's these assumptions that really do shape pre-1960s sexual assault policies today. And to keep it real, these assumptions still persist today, even though those assumptions have been greatly reduced. Okay, so this is an overview of sexual assault policy part one. And so ranging from the prior to the 1960s until the 1990s. Okay. And so first we're going to be talking about until the 1960s, how when it comes to sexual assault policy, that common law is the dominant driver in sexual assault policy. It's common law that determines what kind of sexual assaults were going to be pursued by the criminal justice system. And then the second thing we're going to talk about is the reforms that come after the 1960s. And so it's this move to really codify sexual assault laws into state statutes, to not rely on common law anymore, but actually to have it embedded in state statute and federal statute as well, and also having uniformity from state to state. And that the idea is that if we change sexual assault law at the state level and there's uniformity, then those changes that are made can improve upon the way we approach and prosecute sexual assault in the criminal justice system, and how we can have those reforms uniform across the states. So let's get started by taking a look at pre-1960s sexual assault law defined through the lens of common law. Until the 1960s, the common law is what defines sexual assault, and the common law definition of sexual assault is what prevailed. So just to refresh your memory about what common law is, we've talked about this earlier in the semester, but common law is law that's based on customs and legal precedent. And so common law is often a reflection of the assumptions that are made in society about certain things, such as gender norms, reflections of the sexual mores of that time period, particularly as it relates to common law and sexual assault. And also the way that the law is defined isn't by being written down in state statute or federal code, but rather law is based on legal precedent. And so what the court decides based on norms and custom, what the court decides when it comes to sexual assault, that it becomes precedent. And then that precedent defines how sexual assault will be treated by the next court and by the next court. And so under common law, sexual assault law was rarely written down. It wasn't in state statute. It wasn't in code. And so what do we know about sexual assault as being defined by common law prior to the 1960s? One thing we know is that sexual assault is very narrowly defined. The word sexual assault is actually a product of the reforms that came in the 1960s. That prior to the 1960s, when we're talking about sexual assault, it was defined not broadly, but it was defined specifically and narrowly, and it was defined as rape. And rape was defined also very narrowly. Rape was the penetration of the vagina by the penis and with extreme force, okay? So if somebody's, sorry to be kind of detailed here, but if somebody's vagina or something other than a vagina was penetrated by something other than a penis, then it wouldn't be considered rape. And just because a penis penetrates the vagina doesn't mean that it's rape, but there must be extreme force that's used. That's the only kind of rape that's going to be prosecuted and recognized under common law. No force, no rape. Rape is also seen as a sexual crime, not a violent crime under common law. And the thinking here is that, rape is sort of viewed as sort of a product of a natural desire, right? That men naturally desire women, but rape is sort of like lust gone too far, okay? So rape isn't using sex to dominate or intimidate somebody or physically harm somebody. It's sort of like, oh no, the lust for somebody has crossed a line, and that is something that should not happen. So again, rape in common law is seen as sexual, not as violent. Now, so rape as it's defined is considered a serious offense, and there was a serious penalty for rape under common law. But the thing is that rape or real rape rarely happened. And why was that? Well, that the thinking was is that only certain kinds of women can actually be raped, and the certain kinds of women that can really be raped are either virgins or wives that are faithful. So faithful wives or virgins. Okay, anybody else who is sexually assaulted is really not being raped. And why is that? Well, the thinking is that virgins and faithful wives would fight to the death in order to protect their chastity and their fidelity to their husband. And so, real rape is where a woman who is chaste or faithful would fight to the death in order to prevent a sexual assault, a rape. Anybody who doesn't fight to the death, well, they weren't really chaste and they weren't really faithful. They really kind of wanted it, right? And so we can see that, sort of play out in assumptions that we have about rape today. And so rape is a serious offense and it has a serious penalty, but rape rarely happens. Other types of penetrations or assaults that are not have evidence of extreme violence, those aren't considered rapes and they're not prosecuted because they are not seen as something that rises to the level where the criminal justice system should step in and do something about it. Another aspect of the common law understanding of sexual assault was that wives cannot be raped by their husbands, even if physical force is used. Why? Well, we kind of know the answer to that. It's because up until the 1960s, this understanding of rape persisted, actually beyond the 1960s. But remember when we were learning about the marriage policy, that in the late part of the 19th century into the 20th century, that marriage was seen as a where women, when they got married, they would lose any of their legal identity. So remember that under coverture, women basically become property of their husbands. And as such, wives are sexually available for their husbands. Remember, we learned under marriage that if a wife does something wrong, that the husband, as the legal authority of that house, can punish their wife. If that they can correct their wife. Well, if the husband wants to have sex, then that this is their property, basically, the wife, and that they can that the wife would be sexually available to the husband. And that doesn't mean that there wasn't social norms, right? I mean, treating your wife like very poorly, abusing your wife, even though you weren't going to be prosecuted for it. There were sexual norms that were in place that would prevent a husband from doing something like that. But when we're just talking about the legal aspect of sexual assault, men could not be prosecuted for raping their wives. And as your textbook says, that these laws stayed on the books for quite some period of time, and so most states had marital rape exceptions. That is that you could prosecute somebody for rape unless that person was your husband. That they had those exceptions in their state laws until the 1970s. Now we're going to see, starting in the 1960s, that those marital rape exception laws fall to the wayside. They begin eroding. But it takes time, right? Because, as we know, because of federalism, police power is left to the states, and so states are on their own in terms of defining criminal code and criminal statutes. And so it's not marital rape is not made illegal. It's not criminalized in all 50 states until 1993. So again, another example of the common law definition of sexual assault. So what are the implications of the common law understanding of sexual law and on the criminal justice system? Well, one is husbands can't be charged. Okay, so that's one implication. Another is that when rape was prosecuted, there were very tough standards of evidence that must be presented to prove that a person is guilty of rape beyond a reasonable doubt. And that a lot of it revolves around having to prove that women truly resisted their sexual assault, their rape. And so that the implications for that is that that they must prove that women truly resisted. That means that there has to be physical evidence of force. If there's not enough physical evidence of force, then the burden of proof has not been met. You can't rely on the testimony of the victim alone. In under common law, that victim testimony alone was not enough to convict somebody. You needed to have corroborating evidence beyond the victim. And as we know, in issues of in cases of sexual assault, getting corroborating evidence is difficult because oftentimes rape takes place in a private place, not in a public place where there's going to be other witnesses around. But again, it goes back to that idea that truly virtuous women would scream and scream and scream and scream, right, and bring attention to what was going on. If you didn't do that, well, then you can't trust what the woman is saying. And that also you can present evidence of a victim's sexual history. You could, say that this person wasn't a virgin. You could say that this person was unfaithful to their husband, that they weren't chaste, they gave into temptation once. What's preventing them from giving into temptation again? And so very, very tough standards of evidence, which it doesn't take a rocket scientist to, conclude that most people aren't going to bring charges because it's going to be very difficult to get a conviction. Your textbook talks about the Hale jury instructions. And so judges will, in a jury trial, will give jurors instructions of what they can and cannot consider when they're determining whether or not the person charged with the crime is guilty. And the Hale jury instructions were instructions given to the jury saying that any testimony of the victim should be heavily discounted, right? It's sort of like you can't believe the victim, right? The victim has some reason for lying, right? Whatever they might be. And so while you can take victim testimony into consideration, you really can't put a lot of weight on that in your deliberations regarding a guilt. And as I said, that this, these implications for the common law understanding of rape made it very hard to get convictions. Prosecutors were hesitant to charge people. Why? Prosecutors like to win cases. And so prosecutors, if they felt like they can't win a case, then they're not going to bring charges. And also, from a victim's perspective, if they feel like there's not going to be conviction of the perpetrator, they don't want to go through the hassle of a trial because you're basically because your background can be used against you without any impunity. Then you wouldn't want to put yourself through that. And so that's a summary of the implications of the common law understanding of rape on the criminal justice system. Well, clearly this system needs to change, right? And as we see the rise of the women's liberation movement, we see the rise of second wave feminism in the 1970s, that those changes begin to happen. And as I mentioned earlier, feminists and allies are at the front of these changes. That rape happens, sexual assault happens, but it's just mostly ignored by the criminal justice system. And so feminists and others, they start the public policy process, right? They begin to identify that sexual assault is a widespread problem in the United States. They identify it as a problem and they get it on the agenda. And they, feminists begin to not normalize sexual assault. That's not the right word, but they basically, feminists begin to create safe spaces where women can tell other women and people that they trust that they have been a victim of sexual assault. They're being listened to. And at that time period, there was a rise of rape hotlines, which still are in existence today. Totally confidential places that you can call to let people know that you've been sexually assaulted and get the help that you need. And so, in this effort to, for feminists to sort of say, this is a problem, we know it's a problem because people are starting to talk about it. People are feeling that there are safe places that they can go. They say it is a problem. We need to get it on the agenda and we need to do something about it. And that's what they did. So, what were the goals of the reforms that the feminists and others were pursuing? Well, the major goal was to move away from the common law understanding of sexual assault. And how do you do this? Well, the way you do that is you change the law, okay? And so there is a move towards uniformity in state law. That we saw this with marriage law, right? That you have groups of lawyers, prosecutors within the criminal justice system, and others work together to come up with a model penal code and basically say this is the penal code that should be used state by state, right? And the American Law Institute also is behind that, sort of saying this is how we need to reform sexual assault law. And we'll talk about what those reforms look like in a moment. And the reason to do this is because it provides victims with equal protection, right? That there's model penal code for robbery. There's model penal code for aggravated assault. There's model penal code for arson, right? Well, there should be model penal code for sexual assault as well, because victims of sexual assault need to be given the kinds of protections that other victims of crime are given. And that another reason for doing this is that, as you'll see in a moment, these new state laws made it easier to charge people with sexual assault, and that it increases conviction rate as well. It also, the goals are to change legal standards and procedures within the courtroom in order to protect the rights of victims, okay? Whether those be women or other people who are victims of sexual assault. So let's look at the specifics next. So those are the goals. What are the tactics that were used to improve sexual assault law in the United States in the 1970s and beyond? Well, as I said, that there was a move to adopt uniform laws in states. And what did these uniform laws do? Well, the first thing that they did is they defined sexual assault in graduated degrees with graduated penalties. And if you take a look at Wisconsin sexual assault law, that is exactly how our sexual assault law is. You have a range of behaviors that are defined as sexual assault. The most serious being first-degree sexual assault, and then it goes down from there. And so, at first-degree sexual assault, I think it comes with a penalty of up to 60 years in prison. It is a sexual assault with great bodily harm to somebody. And then it goes down from there, of course, non-consensual sexual assault, right, with great bodily harm. And then it goes down from there. It can, the fourth degree sexual assault, which is a misdemeanor in Wisconsin, is, just non-consensual sexual contact. So if you have some sexual contact with somebody, could be kissing, groping, that is non-consensual, that is defined as sexual assault in the laws of Wisconsin. And those are the kinds of laws that are adopted throughout the country. That sexual assault isn't just rape, but sexual assault covers a lot of non-consensual sexual acts. Sexual assault includes any physical sexual intrusion. It's, again, broadening the definition of sexual assault, not just assault having to do with the actual penis and vagina sex organs. The states also, in terms of improving protections for victims, adopt rape shield statutes. That means that past sexual conduct is inadmissible in a court of law. And so if you are as a defense attorney, you cannot bring past sexual conduct into a court as a raising doubt as to whether or not this individual is guilty of the charge of sexual assault. There's a move away from use of force to absence of consent. So again, under common law, it was all about show that there was physical force, show that was physical force. The reforms that were sought in the 1970s are show that there was no consent, that this person didn't have consent to touch this person sexually. No more. Another reform is that you don't need any more corroboration needed in sexually assault cases than you need in other violent assault cases. So whatever corroboration is needed for any other kind of assault, that's the level of corroboration that you need for sexual assault. You don't need more corroboration. And then finally, it prohibits the Hale jury instructions, that you cannot tell the jury, don't listen to the victim. Okay. And so that's a summary of the ways in which the tactics that were used to reform sexual assault law in the United States. So coming out of the 1960s, or the 1970s and 80s, feminists felt that the reforms that were made at that time were very good, but more of a good first step, and that the reforms did continue to fall short. For one, there was still a low rate of prosecution of sexual assault cases. And then in the 1990s, the early 1990s, as we see rising crime rates throughout the United States, we see rising rates of rape in the United States as well. And so there was a sense that we needed to improve the criminal justice response to violence against women, and that doing it at a state by state level didn't go far enough, and that we needed federal legislation, more comprehensive federal legislation, in order to address this issue. And so in the 1990s, feminists and allies lobby Congress for change. And the change that comes about is the passage of the Violence Against Women's Act that was drafted by now President-elect Joe Biden. And this was a part of the Violent Crime Control and Law Enforcement Act of the Clinton administration. As I said, we had rising violent crime rates in the early 1990s. Now, crime's been on the decline since then, okay, steadily on the decline in the United States. But in order to address the rise of crime, that the Violent Crime Control and Law Enforcement Act was passed. And added to that was the Violence Against Women's Act. And the goal of the Violence Against Women's Act was to use federal grants to train state and local criminal justice agents to do a better job of prosecuting violence against women, that there was increases in making sure that if you had a court order against a sexual assaulter in one state, that was clearly and easily communicated to other states as well. And there were increased penalties if people would leave, sexual assaulters would leave one state to go hide out in another state. And also there was grants given to states to help coordinate for domestic violence shelters, psychiatric treatment for victims of rape, coverage for costs of rape kits, etc. So it was a sort of overarching federal legislation that helped increase addressing sexual assault and have some uniformity between the states. Another aspect of the 1990s change is to focus on campus sexual assault. And so that there is a move in the United States to make sure that, well, for one, there's recognition that there's sexual assault that's taking place on campuses that's not being addressed. And then we asked the federal government to issue a response to that. And so there's a federal law, it's known as the Clery Act. And the Clery Act is basically that if you are getting federal funds in your university or a college, that you need to report out and make transparent the number of sexual assaults that are taking place on your campus. And also there's stronger enforcement of Title IX. Title IX prohibits sexual assault and holds universities accountable if they're not addressing sexual assault. And so there was stronger enforcement of Title IX. Where are we today in terms of sexual assault policy? Well, there's still improvements to be made, obviously, and we're seeing some changes that are coming as a response to the Me Too movement. So, the Me Too movement, one of the problems that we find with the Me Too movement, or that the Me Too movement brings about, is that the statute of limitations for sexual assault is oftentimes the window is short. That if you don't charge somebody within a specific period of time, then they cannot get charged. Well, coming out of the activities of Bill Cosby and his sexual assaults, states have began increasing and extending their time period for the statute of limitations, making it easier for women to charge people even though time has passed. There is a movement to increase the backlog of rape kits that have piled up at the states, and also changing of non-disclosure agreements that prevent people who work in corporate environments and other environments from it allows victims of sexual assault to not be bound by their non-disclosure agreements. Okay, that's a summary of sexual assault law. Uh, I will leave it to you to read about sexual harassment. There's an overview of that in the first lecture. But I know this is a little bit longer than usual, but thanks for sticking with me. There was a lot to cover.